Dr. Samuel Trosow. Dr. Trosow is an associate professor at the University of Western Ontario. Western University.
No, University of Western Ontario.
University of Western Ontario.
Yeah, please.
The joint appointment of the Faculty of Information and Media Studies and the Faculty of Law. Prior to joining UWO faculty, he was a law librarian at the University of California, Berkeley's Bolt Hall Law School, and has his doctorate from UCLA in library science, focused on information policy issues. Please join me in welcoming Samuel.
Here's a rough outline of what I want to talk about today. I want to lay out the general statutory framework. I'm not going to go through the entire Telecommunications Act, but there's one section in the Telecommunications Act that I think is very important. And typically when we're doing statutory construction, we think of these policy sections as being somewhat precatory, not that important. But I think in the context of telecommunications policy, Section 7 is really important. So I want to put this slide up, and I think it's a really important section. Then I'm going to go on and talk a little bit about the foreign ownership restrictions. Is that too loud? The foreign ownership restrictions, general and sectoral, and then look at a case study. Because nobody really paid a lot of attention to the foreign ownership restrictions as sort of a public issue until the Globalized case. And then it started to get a lot of press. People became very concerned about it, especially with the question of, we have cabinet review and we also have judicial review. And I'll show you the different steps that went on in that case. So there was a 2012, earlier this year, the government came out with an announcement moderately changing the foreign ownership rules and also announcing at the same time the rules for the upcoming spectrum auction. And one of the main points we make in the paper, my colleague Michael McNally at the University of Alberta and I are working on a paper, and we're trying to look at the question, will the liberalization of foreign ownership rules actually amount to any net appreciable benefit? To rural broadband service, and our initial hypothesis is no. Yeah, this is on. Is this hello? Is this working? Okay. Our initial hypothesis is not making much difference, and what we've looked at, and Industry Canada has been pretty good about providing background information. We're looking at the licenses that were actually purchased by the new foreign entrants to see if any of them are really going out to underserved areas. So I'm going to spend some time on this slide because I think it's really important. This is Section 7 of the Telecommunications Act of 1993, and this is the statutory framework, and these are the policy goals. And if we had more time, I'd like to sort of ask you to look at these carefully and tell me, do you see any contradictions? By doing one, are you getting yourself in trouble with another? And if you look at these individually, if you pull these apart, they all make a lot of sense individually. My sense is that when you look at them together, you necessarily are going to see contradictions, which means you've got to pick and choose. You've got to decide as policymakers what can you work with up here. If you are from the private sector, you're going to really like F, and you're going to stress F, and you're going to say F trumps the other ones to foster increased reliance on market forces. But none of these trump. They all have to work together. And the one that, I don't know if you can see my bias here for this conference, but I may be a little bit bigger. Because I think that's the one that a lot of people in this room really want to point to. To render reliable and affordable telecommunications service of high quality, accessible to Canadians in both urban and rural areas in all regions of Canada. Now, can you do that at the same time as you promote reliance on the market? But here's the thing. It says where required. Regulation where required. Just because this says foster increased reliance on market forces,
it's not a rule against regulation, and it shouldn't be read that way. And I think the important question is, when you look at how these interrelate with each other, in order to sort of foster some of the policy goals here, at some point, more regulation is necessary. And all this says is it has to be efficient and effective. And sometimes in order for regulation to be efficient and effective, it's got to be very clear, it's got to be very certain, and it has to go beyond just sort of inspirational, aspirational, or precatory rules, and there needs to be some teeth in it. And I think that there's been a lot of talk throughout this conference about various levels of disappointment with the government in terms of not coming up with a general broadband strategy. And I think this is the framework, this is the statutory framework that we have to put this in to respond to the economic and social requirements of users of telecommunication services. Well, that changes as the technology changes. That changes as we see from many of the discussions that broadband is starting to play a much more significant role in people's lives. And we can learn a lot from countries like Finland that have raised that to the level of rights language. And I'm not sure that we need to raise it to the level of rights language in Canada, but we could do that if we wanted to. And the question that I asked the representative from Finland this morning, I was trying to get a better sense of what the source of this rights talk was. And basically, from what I understand, it's a policy decision they made. It's a policy decision they made. We can make that policy decision here in Canada. It would not take a charter amendment. It would just take a will to put a little bit more emphasis on some of these other policy goals. So in terms of foreign ownership restrictions in Canada, we have general restrictions under the General Investment Canada Act, and with respect to 3 sectors, banking, telecommunication, and broadcasting, we also have sectoral restrictions as well. It's difficult talking about Section 16.1 because there's the old version before January 29th, 2012, and the new version. But just to make it simple, I think the main difference between the two is that we're adding this prong to the Canadian owned and controlled test that says, but if they're under the 10% threshold based on revenues, they're exempt from that. So that is the main change that we saw earlier this year. And this came after the whole Global Life set of litigation. Notice that only Bell, Rogers, and Telus are over this threshold. So one of the potential problems with this new statutory regime is you might be creating a 2-tiered system where the 3 large incumbents are under one set of rules in terms of who they can acquire, and the other players are under other ones. Now, if you're under the 10% and you grow, you don't lose the benefit of being under the 10%. All this section says is if your growth is due to merger or acquisition, then you're going to lose the safe harbor that you receive by being under the 10% threshold. Now, in order to determine whether or not a company whether it has the Canadian ownership or control, there are additional statutory rules where you look at corporate structure and you look at the members of the board of directors, you look at the entity's voting interests. And the way this sort of played out in the Global Life case, I have some slides that'll go through that. The 1993 Telecommunications Act established the current system of foreign ownership restrictions. But between 2000 and 2010, there was always some dissatisfaction with these rules. Between 2000 and 2010, there were 5 high-level reviews of the ownership restriction rules. And they were not conclusive. They kept contradicting each other. So you had a parliamentary committee recommending complete removal, 2 special government panels recommending a phased-in partial removal, 1 parliamentary committee recommending no changes. So this is basically what that situation was until this year. In 2010, Industry Canada released a consultation paper, which is posted at that URL. And that consultation paper set forth 3 options. Remove option 3, eliminate the restrictions entirely, and option 1, increase the direct limit on foreign holdings to 49%. Option 2, a phased-in approach. Whenever we talk about changes to the Telecommunications Act in Canada, we also have to remember, and it hasn't come up at this conference yet, but we also have to remember that there's another act that is very closely related to the Telecommunications Act, and that's the Broadcasting Act. Whereas many years ago, several years ago, 10, 15 years ago, I guess that's a lot, the difference between the Broadcasting Act and the Telecommunication Act were much greater, much more obvious. There's been a lot of technological convergence, so much so that many people are starting to ask the question, does it make sense in an era where more and more services, whether they're broadcasting historically or telecommunications historically, are delivered over the internet? Does it make sense to have 2 different statutory regimes with 2 different sets of rules? That's a very interesting debate, and it's beyond the scope of this conference. So I just wanted to mention that in passing. So basically, the last spectrum auction in 2008, we had Globalive. They were successful in their bids, and they were able to get quite a bit of. They won 30 advanced wireless licenses, and they spent $442 million in the 2008 spectrum auction. Now, you might ask the question, why did Industry Canada do a review of whether or not bidders, I mean, you know, you're going to an auction, it's $442 million. You'd think they'd want to make sure that you were qualified. But they didn't really have much of a pre-auction review process, which I think was an expensive mistake. Now, Globalive was heavily debt financed by Orascom and other non-Canadian sources, but they won quite a bit, and spectrum licenses were issued. So basically, Industry Canada issued spectrum licenses to Globalive. They looked at the foreign ownership requirements after the auction. Then TELUS and Shaw, being concerned about the public interest, as they are, so it's very touching, petitioned to the CRTC to review the Globalive ownership. And Public Mobile, which was another entity which actually went to court later on, was not part of the CRTC provision. So just structurally, this went through the CRTC, it went to the cabinet, it went to the federal court, it went to the Federal Court of Appeal, it went to the Supreme Court, and finally the government changed the rules. It didn't go to the Supreme Court denied the review. But the CRTC review of the Globalive ownership culminated in the Telcom decision in October 2009. And they found that they met the first 2 prongs of the test, which are very easy. They're objective. You just sort of count your board of directors, but that they did not satisfy the third prong, which is much more subjective. The CRTC concluded that Globalive did not meet the control and fact test. So there was case law in there. They concluded that Orascom had control, in fact, of Globalive, because of their equity holding, the technical expertise that they provided, and also the trademark. There was also the matter of a lot of debt financing. So the CRTC concluded that Globalive was not eligible to operate as a telecommunications common carrier. Well, I'm going to skip a lot of the text. This is text from the Federal Court of Appeals decision that just goes into a bit more detail. And I invite you to read the Federal Court of Appeals decision in its entirety, because it does a really good job laying out what happened at the CRTC and at the cabinet and in the lower court. So if you just want to read one decision, read the Federal Court of Appeals decision, because it lays out the background. So, following the CRTC decision, the cabinet intervened, and they varied the CRTC decision. The cabinet has the power to do this. They have the power to do this. The governor and council, the cabinet agreed with the CRTC that certain prongs of the test were met. However, the cabinet review concluded that Orascom's influence in Global Life did not amount to, well, they did conclude that Orascom's influence in Global Life did not amount to dominant or determining control. However, it was on the next prong, the subjective prong, that they disagreed with the CRTC. So in other words, what happened was the CRT decision was varied as set out in a very complex detailed schedule that I'm not going to show you. And if you want to read that, you can look at paragraph 15 to 20 of the schedule. It's all set out in the Federal Court of Appeals decision. So at this point, you've got the cabinet overruling the CRTC. And when you have cabinet review, any interested party can seek judicial review of the cabinet review order. Okay? So basically, at this point, Public Mobile, who had not previously participated in the CRTC decision, in the CRTC proceedings, sought judicial review. And the federal court, this is the lower federal court, this is the federal court trial division, this is not the federal court of appeal. The federal court quashed the Privy Council order and reinstated the CRTC decision. They said that the Privy Council acted outside of the legal parameters of the Telecommunications Act. As you might suspect, this federal court decision was then appealed to the Federal Court of Appeal. So you go from the federal court to the Federal Court of Appeal. And the Federal Court of Appeal restored the cabinet decision. If you're following this, they found that since Parliament had granted cabinet the power to review the CRTC decisions, it's for the cabinet to incorporate such policy concerns as the cabinet wants to incorporate. Which I guess is reasonable on the theory that at least if it's a majority government, if people in the cabinet want to do something, even if they can't do it through cabinet review retroactively, they could at least change the act prospectively. Public Mobile sought leave to appeal to the Supreme Court. Now at this point, the appeals as a matter of right have been exhausted, and the Supreme Court does not automatically grant review. It's discretionary. And the Supreme Court in this case decided not to grant leave to review. And this was on April 26th. However, something very important happened between the Federal Court of Appeal decision and the April 26th denial of leave to appeal to the Supreme Court of the decision of the Federal Court of Appeal varying the decision of the Court of Appeal, which varied the decision of the Cabinet, which varied the decision of the CRTC. Right? Okay. So there was a policy announcement on March 12th. And again, if you're just going to read just a few documents, this would be a very important document to read. The March 12th policy announcement. This is just a summary of the different procedural steps. And if you're confused about this, that's okay. It's just the law professor part of me loves this case because you just sort of run the students through sort of like the procedural aspect. And by the way, there's a side policy question here, which I think is a great policy question. Why do we have cabinet review? If there's going to be review anyway, you can go directly from the CRTC to the courts. Why interpose the cabinet review? You don't have that with many of the other quasi-judicial administrative agencies. Why do you have it here? But maybe that's something that should be reviewed. In any event, on March 14th, the government comes out with a very important policy statement. It's worth reading. There was a big announcement. So this is where Industry Canada announced that they were going to create that safe harbor that I showed you earlier for the less than 10%. But they also made an announcement that people were waiting for, and that is the next spectrum auction. There was a spectrum auction back in 2008. We know that because that's where Global Life obtained their license. The second spectrum auction is something that people that follow this have been waiting for. So basically the government announced that the next spectrum auction is going to happen in 2 phases. The first part's going to happen in early 2013. I do not know if that's going to happen or not. Maybe somebody in this room would be better privy to that. But that is going to be for the 700 megahertz sort of portion of the spectrum. And within a year, they would continue with the 2500 megahertz band portion of it. They announced that in the next spectrum auction, they were going to apply some specific measures. The government will be applying caps in the upcoming spectrum auction. 2 policy measures that I'd say the public interest advocate sort of community was asking for were not only caps to make sure that the large, well-funded incumbents did not get a disproportionate amount of the new licenses, but also set-asides. That the government should set aside certain portions of spectrum for particular purposes. Yeah, public safety, what have you, underserved areas, non-incumbents in underserved areas, and the like. There are also some technical things about improving existing policies on roaming and tower sharing in order to further support competition. So basically, this language is all from the policy report, and they attached a technical paper. And for those of you who just don't sort of totally glaze over when I say things like 2500 megahertz band broadband, if you're following that, you might want to read this report, because this report lays out exactly how the government, not exactly, but it lays out in more detail than we knew before how the government is going to proceed with this auction. And this basically is the announcement of the new 10% rule, and we've already seen that reflected. This was announced in March, and it received royal assent within 2 months. This just flew through Parliament, both the House and the Senate. It wasn't even a separate bill. It was part of a 500-page, 600-page bill that had a lot of other sections in it. It wasn't considered controversial. Received royal assent in June. So basically, this is probably an area for further research. How have rural broadband services fared under the spectrum auction? So Public Mobile was able to keep their licenses. Now, for purposes of this discussion, it would be helpful to look at the maps. Basically, when we're talking about a spectrum auction, what's being auctioned off is chunks. And there are basically 4 ways to do the chunks. This is one way. And that's not happening. And the other extreme is this way, where it becomes much more localized. So in between, you have tier 2, where you have 14 large areas. And notice that it looks like the provinces, but when you get in here, the provinces are broken up a little bit, and then you have some combined. You have the territories combined, and then tier 3, where you have 59 regional areas. Now, the previous spectrum auction license, the previous spectrum auction was conducted using a mix of the tier 2 and tier 3. Public Mobile purchased 4 licenses. Public Mobile purchased only 4 licenses, all of which were tier 2 licenses. And 2 of them were in very populated areas, and the third one was in a somewhat populated area. And the least densely populated service area for which public mobile purchased a license was eastern Quebec. This is the spectrum. And if I had more time, I'd take this apart and blow up. There are two parts of this that we're particularly concerned with. This is from Industry Canada. So, Data and Audiovisual Enterprises, Dave Inc., which now operates as Mobilicity, purchased 10 licenses. And again, when you look at the licenses that they purchased, and we need to sort of lay this out from the map, really nicely. We're still sort of in a intermediate stage here in terms of presenting this, but what's becoming clear, or what the evidence is suggesting, is that even where licenses are purchased, even where in the underserved areas, they're not necessarily being rolled out.
In the underserved areas,
They're not necessarily being rolled out. So, licenses for low density population service areas are usually cheaper. Well, of course, they're going to be cheaper. It's an auction. The bidding is going to be less. But a look at Global Live's current coverage map shows that 4 years after that,
Global Live's current
first auction,
shows that 4 years after that
there's no new
first
service.
auction,
And most of what's being rolled out is in the more lucrative.
most of what's being rolled out is in the more
markets.
lucrative
So,
markets.
rollout requirements are
So-
needed. Rollout requirements are needed.
Rollout requirements
Remember,
are needed.
the spectrum is
Rollout
public.
requirements are needed.
It's public property.
Remember, the spectrum
It's-
is public.
It's finite. It's there's only so much of it, and the government has to take
There's only so much.
responsibility for allocating
the government has to
it.
take
So I
responsibility
think saying
for
use it or lose it is another
So I
way.
think-
You can't
I think
you can't
use it or lose it
successfully
is
bid
another way.
on license
You
from the
can't
spectrum
successfully
and
bid
sit on it.
license from the spectrum. And
There's also this document called the Radio
there's
Systems
also
Policy
this document called
019.
the radio
And
systems policy.
it basically allows the government a little bit more latitude
It
to
basically
allow
allows the government a little
different
bit more
entrants who are
latitude
interested in
to
going into someone
allow
else's territory
different
to do
entrants
that,
who are interested
where
in going
the
into someone else's territory.
where it's
to
not
do
being
that,
utilized.
where the-
Our initial
Where it's
thought
not being
is
utilized.
RP
our
019
initial
should
thought
be
is
expanded
RP
to cover other frequencies. It only applies to
expanded
to
to
certain
cover other
frequencies.
frequencies.
So I guess the question here, and I don't think that
So I
we've
guess-
adequately
I guess
answered this in
the
the
question
paper yet.
And I don't
is-
think that we've adequately answered this in the paper.
What are other potential policy mechanisms that could be used
What are other potential policies?
with respect to the allocation of,
With respect to the allocation
of spectrum? And I guess for purposes of our short
I guess for purposes
question
of
period,
our
and to help us
short
answer that question,
period,
I would like to just go back
answer that question.
to my initial
I would
slide
like to just go
and
back
leave that up there for your further
slide
enjoyment.
leave up there.
So
Leave that up there
what else
for
can
your-
we do? So I'm asking you the questions.
What else can we do?
Question over here.
From a structure or policy perspective, have you looked at the restructuring of the license geographies instead of tier 4 to actually look at rural-urban segmentation of the license blocks? It's one of the proposals we put to the CRTC about how to restructure the zone so that you could actually auction or position more rurally focused blocks versus urban blocks. Because right now, if you want anything outside of, in rural Toronto, you have to buy Toronto. Rural, outside of rural Calgary, you have to buy Calgary, and that's tier 4. So from a policy perspective, if you restructure tier 4 with a urban-rural segmentation, you can actually free up a lot of that spectrum that's encumbered by the urban markets right now.
So you would move, you wouldn't necessarily add more service areas, you would just move them around.
Yeah, restructuring based on census blocks and population densities.
That sounds very sensible.
Yeah,
No,
it's-
I
it's
have
in-
not looked at that.
It's in our policy page, within our responses considered.
Okay, I'll want to look at that, yeah.
It's doable stuff.
I mean, relating to that, I think it's also because Industry Canada argues that wireless.
I'll get you a mic here. A mic for Mike.
just related to your point, Bill, Industry Canada keeps arguing that wireless auction in the past have always happened at the tier 2 level. So, and they're reticent to, I understand, do it tier 3 or 4 on that basis. So, it's
Sure,
not
but
an
it
argument.
still, it
but
still
just-
creates
I
a
agree.
major block
I
to
agree.
getting access. My only other comment would be, we still talk about cellular providers as solving rural broadband. That's not broadband, that's cellular service with data, that's not solving rural broadband.
I guess the cleaner it is, the easier it is to demonstrate that even after the auction, there are territories that have not been bid. It's probably easier to make the case that there's a market failure and other approaches need to be taken.
So I think we've got a response over here from Mike and then a question from Wesley.
Not so much a response, more in addition to, in terms of policy mechanism. Another kind of big picture question I've had in the past is, why doesn't Industry Canada have an arbitration mechanism for whenever there's, well, you know, what's commonly known as spectrum hoarding? So when the players aren't utilizing or employing the licenses they have.
Good, excellent question. Excellent question.
I think we've got a question from Wesley.
I was just wondering, have you looked into why the government shift from having spectrum caps for incumbents versus having spectrum set-asides for newly entrants coming in? Because I know back before the last auctions, you know, there was a certain amount of spectrum that was set aside for new entrants to come in. And now there's a shift towards from spectrum set-asides to now spectrum caps, which prevents, you know, incumbents from taking in as much spectrum as they can.
I got the idea from, no, I don't know the answer to that, it's a great question, but I get the idea from reading these reports that the government would like to stay away from set-asides because they have to decide what they're gonna set aside. There might be other reasons. I think it might have something to do with, they're running an auction here, you know. You're running an auction, and you want your goods to sell, and you want to keep it as simple as possible, and you don't want to encumber your product. I guess.
Yeah, because I personally think it's a flawed system because you have newly entrants coming in, and what they do is with, like, you know, they have like it's called gaming opportunities where they sit on the spectrum, and what you find is that they really have no intention of buying the spectrum, but they just auction it and then they just drive up the prices so that to increase the prices, and then usually they just leave out. Once they were overbid, then they leave out, but usually they sit on the spectrum.
Yeah, both RP19 and rollout requirements would at least ameliorate that, or perhaps something structural to keep that from happening at the beginning. Like you make an undertaking that you're going to do something, and you back it up before you even bid. Don't come in here.
I think we have one last question over here.
This is actually just a comment for anyone who's interested, is that there's actually a consultation process underway right now on the renewal process for 2300 megahertz and 3500 megahertz, and it closes December 17th. So if anyone's interested, then they can follow that and make comment to the CRTC either publicly through that or government to government if that be thou desire.